Nehru Dialogues and Yoda Press. We welcome you on the occasion of this discussion or this wonderful book, Trials of Sovereignty, Mercy, Violence and the Making of Criminal Law in British India. And it covers the period of 1857 to 1922. The author, Alastair McClure, is here. He teaches history at University of Hong Kong, and Dr. Aparna Vaidik, historian, teaches history at Ashoka University. I am not going to speak much about the book. I leave it to Alastair.
Okay. Well, firstly, thank you all for coming today. It's a real pleasure to be speaking here in an institution that is doing so much to maintain space for critical thinking around the arts in Delhi. I wanted to note it's a special pleasure to be speaking in Delhi. This book really wouldn't have been written without the many conversations I've had with friends, family and colleagues, some of whom are in the audience today, as well as the institutions and archives and libraries in the city. So it's a special pleasure to be speaking today. I thought before I'd start, I'd also just like to thank Yoda for agreeing to publish this book in their fantastic catalogue, and in particular to thank Arpita Das and Ishita Gupta for all their hard work in getting it to print and for organising today's event. And also to thank Professor Vaidik for agreeing to speak. She's worked on many connected issues, and most recently her most wonderful book on Bhagat Singh. So thank you for agreeing to be here. So I'm going to speak just very briefly, for about 10-12 minutes, about the book, briefly to give you, hopefully, to give you a sense that it might be interesting and worthwhile. And so to do that, I thought I would speak about two of the questions that really animated the project. So the first of these is a question really, why might violence be recognised as an important site of study, an important site of study in a context that we know is characterised by so much violence? So to think about this question, I wanted to talk about the trial of Bahadur Shah Safar II, a source that in earnest really got this project moving, and one of course that has special relevance to Delhi. So as everyone here will know, Bahadur Shah was the largely symbolic leader of the uprising of 1857, and as the rebel movement begins to collapse, Bahadur Shah would surrender on a negotiated agreement that the British would promise to spare his life. Now, what followed was much discussion amongst colonial officials about what to do with the most famous prisoner of the period. Now, as you can see on the screen here, many senior officials at the time were calling for his head. But it was ultimately agreed that the promise would have to hold and his life would be spared. He is placed on a show trial in the Red Fort, where he is charged with treason and murder, found guilty and transported to Rangoon, where he would live until his dying days. Now, there had been some really excellent scholarship on this trial before my book was written, and that had largely examined this episode as another example of the hypocrisy of British claims to governing through a rule of law. They pointed to the fact that even in the 1850s, this was clearly a transgression of international law. There was no jurisdiction to try a living sovereign as a subject of the British. And in doing so, they argued that this was an example of a bare, untrammelled expression of sovereign power. Now, as I was reading the trial, I still felt that the existing literature was failing to capture some of the strangeness of this episode. So what do I mean by that? Well, because Bahadur Shah's life was guaranteed before the trial even begun, the colonial government decided that the court would not be given the power to decide punishment. They would simply decide whether he was innocent or guilty. This was because, and as the book looks at in some detail, the colonial government realised that it would be much more useful for them to decide how to punish after the trial. And that was because they recognised that the Indian people saw Bahadur Shah as a legitimate source of political sovereignty in a period in time when the colonial state itself lacked popular legitimacy. And so the question of punishment would be decided after the spectacle of the trial was concluded. Now, as we all know, though, this is not a period of history that the colonial state was shy about committing violence. This is a period in which the state was committing a ruthless campaign of retributive terror. And yet in this instance, the most important leader of the movement would be tried in a court that lacked the power to decide punishment by a state that decided it could not kill. And so, can we move to the next slide? Thank you. And as I was thinking about the strangeness of this episode, I returned to what is often considered to be the basic mark of sovereign power, the right to kill or let live. And I realised that scholarship in colonial India had very understandably only really focused on the first half of that formula, the right to kill and commit acts of violence. And yet in this instance, we found officials deciding, for various reasons, that state authority was best bolstered in the decision to let live. Now, this, of course, had nothing to do with a sincere sense of British honour or benevolence or a notion that justice should be tempered with mercy. But I nevertheless thought this decision deserved taking seriously. And so, at that point, I went back to the archives to look for both acts of terror, but also acts of leniency, discretion, and mercy. And when I did that, I found material quite easy to come by. So I found general pardons and amnesties organised after almost some of the most infamous periods of martial law and state violence under colonial rule. I found some of the most scaffold-hungry courts in British India, also at times deciding some subjects were deserving of lenient sentences. I saw intense debates around the prerogative powers of pardon in India. And I also found controversial backroom discussions about when and under what conditions anti-colonial leaders might have their sentences commuted and be released early, none of which I felt had been adequately explored. And so the first puzzle of the book was to work out what politics was at play, what political work were acts of mercy doing in an otherwise bloody and penal order. So as I put that puzzle back together, I want to stress here the book is by no means suggesting that the colonial state was any less violent than existing scholarship has shown. Instead, the first argument of the book is that it's by studying empire through a careful notion of discretionary justice and mercy that we actually understand its terror much better. We learn how existing social hierarchies were strategically incorporated into a bloody political order. And in the process, we equip ourselves to understand the unevenness of colonial violence, to think about how caste, class, gender, and race were integrated into the decision to punish. And so this led me to make the argument that mercy and terror should be recognised as related expressions of sovereign power, and that the discretion to decide when and how to punish would become a key strategy of colonial rule, enabling judges and officials to govern through a legal code that terrified the majority while ensuring conditional leniency were available to a small minority, almost always elite subjects, who would continue to approach colonial institutions, ask for justice and seek mercy, conferring the colonial project with its thin veneer of legitimacy. Can I move to the next slide? So the second question I wanted to pose came from a very different line of inquiry. And here, over time, I became interested in how aspects of my story were playing out relatively commonly in contemporary public debates in both Britain and India, but in very different ways. So in Britain, as many of you will know, for the last 20 years or so, historians with a progressive intellectual bent have been trying to make the case that people should think much more critically about the place of empire in Britain's national historical memory. And doing so, they have stressed the violence and the brutality that underpinned the extension and consolidation of colonial rule across the world. Now, of course, in the conservative culture that is Britain, that has been a site of contestation and pushback since its very inception. However, if in the former metropole it is the question of empire's violence that courts controversy, the same, of course, is not the case in India. Now, one of the few points of consensus across the political spectrum in post-colonial India is that empire was a bloody, extractive and a business. And so where you do find controversy and contestation, of course, is in the history of mercy. So on the screen here, you will see a picture of Rahul Gandhi at a campaign rally holding up a copy of a document from the National Archives of India, which, as many of you, I'm sure, will know, spoke to the archival record of V.D. Savarkar's rather long list of mercy petitions submitted to the British for commutation. Now, I want to make it clear that up front that the book is not really about Savarkar or his petitions. However, controversy around this issue, one that so regularly courts debate, is certainly worth some comment. So, as part of the broader attempt to rehabilitate Savarkar's place within the history of the nationalist struggle, sympathetic historians and commentators have been working hard to expressly downplay the significance of mercy. They have argued that his petitions were simply bureaucratic procedures, empty of political significance, pragmatic and necessary efforts to win freedom, a strategy common to many nationalist figures of the time. Trials of Sovereignty, however, demonstrates that these arguments require an extremely shallow reading of the role mercy played as a crucial tool of empire. It also, however, requires that we ignore a vital aspect of anti-colonial political thinking and strategy. Namely, that by the early 20th century, some of the most influential leaders of the movement, and here I'm talking about Tilak and Gandhi especially, had in fact recognised that accepting British mercy was a trap, and a very serious political problem that was curtailing the possibility of full political life under colonial rule. So go to the next slide. And so in the book, I show that by the early 20th century, Tilak had in fact created and crafted very strict rules about when and under what conditions mercy was an appropriate thing to ask for. It was because he stuck so fastidiously to those rules that his petitions would fail and he would be forced to see out his full sentence in jail. Meanwhile, by 1920s, Gandhi had not only recognised mercy as a serious problem, but had successfully remade the rejection of mercy into a formidable act of anti-colonial resistance. And so Gandhi talks at length about how the Indian public should not be what he calls lulled into sleep by the offers of British mercy. And some of the quotes on the screen here are other examples of him talking at length about the issue during this period. This discovery, the notion that mercy was causing serious damage to the nationalist movement, I argue was a key moment. That it demonstrated that a broader understanding amongst some of the most important leaders of the time that the pursuit of full Swaraj was impossible while Indians continued to approach colonial institutions and exchange mercy for their politics. It was therefore only when mercy was fully rejected that a mass nationalist movement would emerge that no longer spoke the language of imperial subjecthood. And so the second argument of the book is that contestations around mercy should be taken very seriously as a key and hitherto understudied aspect of the history of anti-colonial political thought and Indian nationalism. And so those are the sort of two main claims the book looks at over the course of sort of 7 chapters on different issues. So with that very brief introduction, I think I will pass the floor over to Professor Vaidik. Thank you.
So I haven't prepared grand speech on this. I'm going to walk you through the book, because there's a lot more to the book than Alastair's modest presentation let you believe. So first thing, this book, when I started reading it, it takes on board 3 major trials at least: Bahadur Shah Zafar, Tilak's trials, and Gandhi's trials, and then several records from the Allahabad court, right? So I was like, how many years did he spend researching it? Because looking at trial records is not easy at all, because trial records are reams and reams of paper with several people speaking at the same time. Yeah, and almost it's like looking at entering a forest with lots of birds, cacophonous completely. Yeah, so if you're looking at 3 trials, so then I asked, how much, 8 years you said?
Yeah, maybe 10 years.
10 years. So yeah, a book like this is like about 10 years in making, because you would have to see that level and that depth and that vast record. So I just wanted to highlight that this is a book based on deep research, long research. A lot of time has been spent on it. And then I was like, I wish somebody had told him he didn't need to do so much. This is a lot of hard work. So, but that doesn't take away, like, this is a great book to read. So, but the hard work is evident, and several archives that he has consulted. So, just for you to know that the Allahabad High Court Criminal Records Room, I can't even imagine what it looks like, because it must be a dusty old room with, again, thousands of pages of files and all of that there. British Library Records, Cambridge University Library, Liverpool Record Office, Maharashtra State Archives, National Archives of India, Nehru Memorial, and 4 archives in Uttar Pradesh. that must have made him fluent in all the Hindi curse words now. So, and a lot of published case laws and journals and periodicals. So there's a lot of, and maybe I'm emphasizing this because we are living in an age of, a lot of fake writing, and where history is just being produced, like it's about narratives and all that, but this is what it takes to research a good book and write a good book and make new interventions. So, okay, having said that, so let me walk you through a little bit through the book, a little more deeply than Alastair did. So I think he was just being modest because we, So the book opens with Bahadur Shah Zafar's trial, as he said, and I'll also give you what it did for me, the kind of thought process it shifted for me. So there, in that chapter, he is arguing against a lot of scholarship because Bahadur Shah Zafar has drawn the trial has drawn a lot of scholarship. So he's not only drawing and engaging with that scholarship, but also stepping away from it to say that how do we even understand it? That here is a ruler, there are other people who are not even the rulers of the land, and now they're suddenly adjudicating the victor's law and deeming this person to be a subject. So how does this even happen? So he looks at the nitty-gritties of the case to show us how Bahadur Shah Zafar was brought into the law. So he's a man outside of that law, and in doing that, the law is being created. Yeah, so how is he being brought into I think I'll look at my notes so that I don't take up a lot of time, because we want him to read his thing. So yeah, okay, I started with the trial of Bahadur Shah Zafar, but I wanted to first summarize what the book was about. So can I just backtrack? And I'm going to come out of the Bahadur Shah Zafar trial and just quickly give you 3 historiographical interventions that the book makes. So one is terror and mercy, the fraternal twins, and I think none of us before this have thought about mercy in this way. So terror and violence is what has garnered a lot of scholarship in last 10-15 years. So post 9/11, a lot of South Asian scholars also began looking at violence, terrorism, and militant anti-colonial resistance, and especially looking at networks, global networks, and all that. And my own work is sort of located within that sort of shift, historiographical shift. And before that, also there was a presumption about the colonial state or the British rule as being more benign in comparison to, say, the French in Algeria and other places. So the scholarship in last 10-15 years has shifted that notion to show us that terror was central to the way the British were doing their empire in India. And it is interesting, there are reasons why historians didn't visit it earlier. But now I feel that Alastair's book is marking another shift in historiography to talk about mercy as, I'm calling it a fraternal twin, he doesn't do it, but of the idea of terror. So he says, according to him, if you want to understand terror better, you need to look at mercy. Yeah, and because sometimes mercy was being offered in order to justify the terror that would follow. Yeah, or mercy was being offered to obliterate or erase the terror that the state had just inflicted. So mercy in that way is important to understanding the way the state does terror. So that's the first sort of historiographical intervention he's making. And his focus, you may not be thinking you're doing that, but I'm thinking you're doing that, okay? So the book is focused on making of the law. How does the Indian Penal Code get created? Yeah, and how does it appear in legal practice? Because one is the making of the code, what went into the thought process of the administrators making the code, but what happened once it started playing out in the way different trials took place. Yeah, so that's one. Second is he's questioning the idea of colonial difference. So again, I'll just give a quick background to this idea of colonial difference. Now, I think it was Partha Chatterjee's idea, no? So Partha Chatterjee in his writing talked about things being done differently in India because the colony was seen as different. Simple, I'm simplifying the argument, that there's a colonial difference. So the British justified a lot of things they did in India premised on the idea of colonial difference. Now, Alastair's book questions this idea of colonial difference. And here is how he does it. According to him, just looking at colonial difference or using that as a framework to understand lots of things that are going on in India, divides our vision into colonized and the colonizer, into a Manichaean world. But he says if you look at these trials closely, what you find is it's not just that the colonial exercise of power was inflicted by race, but it was also inflicted by patriarchy, caste, and gender. So the picture was more textured. You can't just say colonial difference and as if India is one homogeneous whole and England is one homogeneous whole, but there is a lot more going on here. And that texture you get when you are looking at the trial records and these variety of trials that he's looked at. So what he is showing is that the law is not above the society. The law is not outside the social. So the social context. So, what I really enjoyed about the book is that it continuously contextualizes the way the law is being constituted through practice. Yeah. So, So the context, in his book, the context is very important. The social is very important. And how that continuously is in dialogue with the state practice. So there is a very nice sort of back and forth between states' policy making, that getting altered through the practice, and the social mores and various things in India impacting the lawmaking again, and that, so it being a more dialogic space. Yeah. So that's again looking at law as a dialogic construction, and instead of just saying, oh, the British made it, or saying, oh, because of India, the law was like this. So because in both the things, the idea of colonial difference remains intact. So he's destabilizing that idea. The third thing he does is he's saying colony is not a state of exception. So the idea of colonial difference some scholars have used. Then some scholars have said that India is in a state of exception. How do we explain that? That what's happening in India is unique.
The rules don't apply, basically, right?
They're exceptional, they're unique, and that's not something that happens in England, right?
Yeah, I guess so, yeah. I mean, there's that phrase by Chele Mbembe, right? He says in the colony you can kill anyone at any time, anyhow, right? And so it's a constant state of exception, I think that was
so even if there's a rule, the rule may not apply. We can create exceptions to everything that's going on. And so colony is seen as a space where everything goes. Now he's saying, guys, switch off your phones. Yeah, it's more enjoyable. Oh, you're also getting distracted with the phone rings, Anna. Can we do a phone check quickly? If everyone's, it rings by chance. And having said this, mine will ring in a minute. No, but I did silence it. Agli baar, next time you guys need to deposit your phones. Yeah. So I hope everyone's done their check.
I've done mine.
Okay. So what Alastair is saying is that colony is not a state of exception. So what is happening? How do we then understand the colony? Once we've said, okay, we've thrown out this idea, it's not applicable. So how does this work? What he's saying is he's drawing on this one scholar who has looked at histories of oceans. Yeah, her name is Lauren Benton. And what Lauren Benton is arguing is that there are several legal orders operating at the same time. Yeah, so the word she's using is plural legal orders, right? So that's the idea he's drawing on, and he's saying so several different legal orders are operating. No, he's not saying that. He's saying the situation is he's drawing on that idea to say it's more complex than simply it being a state of exception, and I'll tell you in a minute how. And there is an unevenness in the application of law. Yeah, so the ultimate, the argument he is making is that the idea of political sovereignty, ये राजनीतिक स्वायत्ता का जो idea है, it's not a settled thing. Yeah, it's continuously up for revision, up for thought, and it's an unsettled idea. Yeah, and the unsettling happens even more when Indians stop buying into, like Gandhi and Tilak, these trials, they actually stop buying into the colonial fiction that has been created for them. Yeah, so these are the sort of historiographical interventions that the book makes. Now, shall I just quickly walk you through the book? Yeah. So first is the trial of Bahadur Shah Zafar, and he's saying in that, even before the trial started, they had decided that they're not going to kill him. Yeah, they're going to keep him alive. So, and Alastair walks us through that process of how come these officials are thinking that, and what does that do for Bahadur Shah Zafar and the idea of sovereignty. Yeah, and what I really liked was, because I think you carve it out really well with Gandhi also. It goes, he says, what the trial did was, it generated a political fiction that the ex-king was the focus of the rebellion. And this allowed the British to downplay the rebellion's popular character. तो एक आदमी को पकड़ो, उसको पकड़ के exile, and then, you know, he's like the lightning rod, and he's not even sent here and there, he's sent to Burma. So he's kept far enough but close enough also in some ways. And so what he says is the state, the trial was, this was an opportunity for the state to reframe its inability to kill into a performance of magnanimity and benevolence. It actually couldn't kill because killing would not have served the purpose that it wanted. Yeah. So and here he is questioning a historiography which says that this was a way of ousting Bahadur Shah Zafar from the body politic. Exiling him was a way of removing him. So Alastair is making a different point. He's saying, no, this is not putting him outside the body politic, but it is one who was previously outside, you're bringing them within the law. So the new sovereign law of the British required the previous king to be reduced to a criminal subject. Yeah, you could not treat him like a ruler. Yeah? So that's the significance of, historiographical significance of the point he's making. And then again, you know, it's very interesting that I was reading political history of this kind after a very long time. Yeah. So the next he tackles the Queen's Proclamation that all of us have read about in our school textbooks from the time we started reading history in school. That Queen's Proclamation, 1858, India is transferred from East India Company to be a crown colony, and thank you for that. And that, so, and in the proclamation, amnesty is given to the rebels. So he's asking, what purpose does it serve? When you had killed so many, you could have killed more. Yeah. So why not kill everyone? Because they could. Yeah. So he says what the amnesty was trying to do was, it was an instrument of post-conflict resolution. That now, okay, a lot of conflict has happened, all of us are going to be good to each other, we're going to proclaim amnesty. So it was that, but it was more than that. Yeah? It was a way to generate willful amnesia. Yeah? And what was the amnesia? To bury the memory of the violent past. So, and from here they start spinning the political fiction. That the Indians were misled by their ex-ruler and like that. And you know, this point is important because then later it feeds into the sedition trials. Because Tilak and all these newspaper editors and Gandhi, when they are being trialed, that's the charge that is being levied on them. That these are leaders who are misleading the people. And Gandhi and Tilak in their trial actually contest this very charge. To say that what we are doing is actually what people are saying. We are just representing. It's the people's wish that we are representing. So that's the interesting sort of tenor that is there, the thread that binds all the narrative arc of the book. And the proclamation also allowed for the penetration of the state. Okay, so okay, very quickly then he talks about how the law is made, the codification of the law. So you know, Radhika Singh has worked on the CRPC to say that what did she say? That there
discretion is really important, right?
Yeah. So okay, I'll try and summarize 2-3 chapters in 3-4 lines for you. And you please help me.
Sure.
So what he's saying that in the formation of Indian Penal Code, we think that it's coded in post 1857. The conditions after 1857 led to the coding of the making of the code. So he's saying that it's not just a causative factor, but a constitutive factor, the revolt, because it changed the way they were doing law. The British were doing law. So he takes a lot of time and compares the law as framed by Macaulay in 37 to the 1860 IPC. What are the shifts that happen? And those are really very interesting. The kinds of things that remain and the kind of things that change. Yeah, and read the book for that. So because it'll take me a lot of time to summarize what changed. So, but it's really quite interesting what the state decides to drop. And one of the things I'll tell you what it drops is the word caste. That's one of the very interesting things the book highlights. And if you want to understand some of the law and caste politics, then you can turn to this book and see how the British are now not talking about caste in the law, but practicing, but it is there in the practice of law. So how it is invisibilized. That in the practice, caste continues to be practiced, but in the IPC, they remove caste, the word caste. Yeah. And another very important idea that gets embedded, a practice that gets embedded in the law is the idea of discretion. Do you want to say something about that? As a summary, you can come in and say, no?
Sure, I think that and it connects to the caste question, right? The discretion becomes a means to envelop things that you don't want to write into the law into the practice because you have wide discretion, right? So
yeah, so like the judges are given discretion. Now, example is like the murder trials. In murder trial, the law in England was if you murder someone, you're going to be, you will get death sentence. But in India, there were caveats were built into the law. So there were 5 discretionary
exceptions.
5 exceptions that were there. And if you, so after every this thing, the judge will ask, does this case fit any of those 5 discretions? Yeah, the 5 exceptions. So the judge actually had the discretion to decide that. So this idea of discretion is not just like when we look at our law, we experience that arbitrary. Oh, they freed this one and they didn't free that one. But it is not arbitrary. It's a discretion built into the law. And here you get the long, deep history of this discretion. That this discretion experienced is arbitrary today by us. Or we say, oh, the judges do everything and the judge is not following the letter of law. Or you argue the judge and you don't argue the law in a court and all that. No, actually there is a historical background to this. And this book and some of these chapters, and it provide you with that background of how discretion is built into the law in the Indian Penal Code. Yeah, and do you want to add anything to it, to the discussion?
I think the discretion is interesting. One thing I just had about discretion which is interesting is, and this is what Madhika Singh had said before, is that the idea of codification is that you remove it from the law. So in the common law, judges have too much discretion, and so codes are to reduce discretion. But then actually when you look at the code in all these important areas, they produce more discretion for judges in the colony than in England. And so this argument that you're doing codification to reduce discretion looks very strange when you look at the code itself and find there's discretion everywhere. And so that's the sort of one of the thing that chapters sorts to sort of play out.
Yeah. And then judges and the jury also, right? So there are interesting sections about the jury in the book. And actually it answered a question I had been asked once of why Bhagat Singh's trial, why it was not a jury trial. And I fumbled obviously because I hadn't thought about jury trials at all. But this book actually gave me the answer. Because there is no jury trial in Punjab. So jury trials were reserved for only certain areas of India. And the criteria was, I think, education.
It was like a civilizational logic. So they
Yeah.
would keep it
Okay. Have you guys heard me so far? Okay.
Yeah, so there was a sort of civilizational logic. So almost every district was marked by the kind of notion of being an advanced or not advanced district. And then if they were advanced, they would have a jury. If they weren't, they wouldn't. But actually, what you see is that very few districts were seen as advanced. And over time, it just reduces and reduces. So you have very few jury trials for most offences under the IPC, which is actually a really important aspect of how you decide and who decides how to punish. So that's sort of one of the things.
Yeah. So, and we're going to come back to the civilizational logic because I have a question about it that I wanted to ask Alastair. And then the book's narrative arc shifts to showing us how, there are public... So murder trials become the focus and of where the discretion lies. So he pivots to showing us some of these murder trials, evidence of these murder trials, and who gets public executions and who does not get public executions. Yeah, so often it is the lower caste folks or criminal tribes when they are being given death sentence. The public execution continues, but in the case of middle class or more respectable classes or the revolutionary revolutionaries, the execution is in the jail. So this also sort of clarified to me why some of my own sort of gave me background to my own writing. And then he connects it up with Tilak's and Gandhi's trial. I think he's said enough about it, so I won't summarize much. And this idea of rejection of colonial mercy, I sort of connected in my mind to the jail hunger strikes that many of these revolutionaries undertook. Okay, last 2 points that I had to say was, I felt that after reading the book, I wondered, these are just sort of thoughts, if this book would help me understand or can be a framework to understand the founding of the Indian Republic. Because I felt there was a clear parallel between the violence that had taken place in 1857 and the partition violence. And post that, the Queen's proclamation comes. And post the partition violence, the founding of India happens. So I wondered if if we can use this idea of the willful amnesia, I felt it had parallels. Because, and not being able to reckon with that violence, creating that unease in the Indian state. The anxiety of the Indian state today, or in earlier periods also, can we say that it's that inability to mourn, the inability to reckon with that past. And the same kind of anxiety the colonial state was inflicted by. So that was one. And also I wondered if this book could be also read as part of many things, but read as part of this growing literature on corruption. Like William Cole's work, and I think there are a few which have written about post-colonial corruption, that the politics of discretion, how that continues, that has expanded and taken on forms which are actually corrupt. So, because it said like the forgiveness, mercy is never really spelled out how it's going to be given, and this was by design. So, and the fact that property becomes vital in the way mercy functions, caste becomes vital in the way it functions, and it's playing out in a even more magnified form today. So I felt as if the book gave me a sort of a prehistory, a backstory to also understanding what became of the Indian state. So I think here I will stop, and we can have you come in. And do you want to reflect on this?
Yeah, that sounds
Start
good.
with this, and then I can ask 1 or 2 questions.
Sounds good, thank you.
Yeah.
Thank you. You did a much better job than I did at explaining my own book, so thank you for that.
That was my job.
Thank you. No, that's really fantastic. I think I'll just touch on the 2 questions you raised because they're really interesting. I think there is a parallel between 1857 and the colonial state and partition and the post-colonial state. I think actually the differences are in some ways more interesting than the similarities. In a sort of so amnesties in a democratic tradition, or forgiveness in a democratic tradition, say the Truth and Reconciliation in South Africa, is supposed to be a participatory thing, where people participate in the act of forgetting, right? That we have to agree that to have a sort of consensual politics, we all have to participate in this thing. Now, in the colony, it's completely undemocratic. So amnesty is sort of imposed on the colony, and the alternative to amnesty is terror. Right, and so that's because the colonial state isn't trying to build a democracy, right? It's trying to build a despotism where everyone has to be deemed not yet ready for political life. Now, the amnesty is an attempt to bury a memory of a form of violence. That's what it's trying to do, but to do so to create an undemocratic state. Now, the interesting thing about partition is that there's almost an impossibility of an amnesty because rather than you end up with 2 states, right? And so it's very hard for those individuals, instead of having one political body, you have 2. And instead what you have is the founding of this sort of enmity between India and Pakistan, which is constantly sort of raked over within each nation state for their own political gain, right? For sort of right. And so what's interesting now and very sort of sad is that, say, the attempt to recover partition violence now is really something that the right wing want to do, to continue to sort of cultivate that sense of an enmity, right, the enemy within. And so actually the inability to forget, or the impossibility of being able to forget through a sort of democratic tradition in a way that would enable a consensual politics, in some sense enables a sort of increased, intensified nationalism on both sides of the border. So I think that is the similarity, right? There's been an impossibility of forgiving and forgetting, but it's slightly different than the colonial state, which was an attempt to use amnesty to paper over a popular political movement and replace that memory of a popular politics with the absence of popular politics and the imposition of a despotic colonial state. So those would be the sort of differences I'd suggest. The corruption question is really interesting, right? Because the whole point of discretion is that they sort of smuggle in a very clear politics where the law will say everyone is equal under the law, right? With some caveats, of course. This is not. But the purpose is, the Queen's Proclamation says it, right? Everyone will get equal justice. The Penal Code, one of the first pages of the Penal Code, it will talk about equality. But the explicit intention of the wide discretion is to exactly enable difference to be smuggled back into the law. And then after that, the book sort of looks at all the different ways in which the processes, in which that difference along caste or religion or gender is entrenched and deepened over time. And so it is a form of corruption in the sense that you have a language of equality and you have an explicit and express, if backdoor policy of something very different, right? Where you're not sort of delivering equality, you're delivering sort of, huge degrees of injustice, and, the experience of that justice is very different depending on where you fall in the social order. So I think, I haven't thought about it as using that framework, but it's true, there's an absolute parallel there. So, I think that's very interesting.
Yeah. So, let's check if this is working.
Hello?
Yeah. Okay, great. So, another thing I was intrigued by was your lack of usage of two terms. So one thing that kept coming up in the records that I've looked at in terms of law, legality, crime, is this idea. I'll say it and then I can explain it to the non-historians, non-specialists in the audience. It's the mendacious native. There is a mendacious mean is a lying, deceitful person. Yeah. So there is always in the records this idea that we need to use law, better law, because law is objective and apolitical and all of that. We know it's all that is BS, but that's what they say. Law, and we need to use science because the native testimony or the native is mendacious. They're deceitful. They're untruthful. Yeah. So it is very interesting that in my mind, when I'm thinking about state and the native, I'm thinking the state is going to look at them as liars. And there was this old framework of Kipling, of the noble savage and all that, and then there is that the native is uncivilized. So in Alastair's book, the word civilization is there in the proclamation, and the more civilized and not so civilized is the marker of law and the way the law will organize the people. Did you not come across the mendacious native?
No, I did, and I actually wrote something a bit after my book. The first thing I did was about this exact thing. And the idea of the mendacious native who can't be trusted in the court is actually, as you say, it's a justification for why judges have so much power in the courtroom, because that's why they say we can't have jurors. Indians can't be jurors because we can't trust them. That's why we can't trust them as witnesses. That's why we can't trust them as doctors. And so what happens is that language is constantly used, but the result is to give more and more authority to what is almost always a colonial white judge, right? Now, that is one part of the story. But what's interesting, and what I was also interested in, is that when you share decision-making across the courtroom, it also means that the court is insulated from some of its decisions, because the people are in the court as jurors, participating in the decision-making process. Now, when you remove everyone from the court except for the judge, what that means is the responsibility for the decision is just the judge. And what that happens is in the colonies, by the 20th century, the judge becomes a figure which is ridiculed, rejected. The courtroom itself has no legitimacy amongst the people because the people aren't allowed to use it. So by the 20th century, although that language is still there, it's no longer able to perform the work of creating a legitimate or the idea of a legitimate political project, because actually the courtroom has not been able to insulate itself in the way that it would have done if they enabled people to participate in the process. So it creates that problem.
So, like, your work is showing that although there may be a discourse of the mendacious native, it is the court that comes to be seen as mendacious, or the state, by the time we come to the Gandhi's time.
Exactly. I mean, that's what the and the nationalists are basically what justice is this, right? And one of the interesting things about Tilak does, which people have written before me, is that in sedition trials there is often a special jury, and the special jury is used where you have basically to ensure it's a higher bar, English bar, which means the majority will almost always be Europeans. But Tilak still speaks directly to the... By 1908, Tilak refuses to look at the judge. He stares straight at the people, the jury, which is seen to be a representative of the people, and only speaks to them. Right? He says that I will tell them my case, but I'm not looking at the judge themselves, even though that jury is still 6-3 or 7-2 Europeans. And so it becomes a way which, you know, you can ridicule the idea of justice, but you play with the, as you know with Bhagat Singh, right? You can play with the etiquette of this thing.
Yeah, they completely, play with the judge. Okay, and my other question, I'm forgetting at the moment. But it'll come back to me. I didn't write it down. But do you want to use this more we'll invite questions from the audience also. Do you want to read out?
Sure, I can read a little bit. I don't know if I read too long, you can just start shouting at me or something.
We have time, you know. Yeah, just, would you guys want to hear what he has written? It's a nice text. Let's have a reading, yeah.
Okay, can I have a...
Yeah, take the book.
Thank you. I thought Gandhi was too easy, so I'll go with Tilak. So this is from chapter 6. This is after Tilak's second trial where he's been convicted for sedition. And he sort of undergoes what I say is the sort of process where he discovers the politics of mercy and empire. So from 1909, Tilak had also begun discussions regarding the possibility of petitioning for mercy. The issue was first broached by Kapade in a letter to Tilak following his failure in the Privy Council. Kapade suggested that an early release might be possible, although this would likely be contingent on conditions more stringent than in 1898. Tilak would need to either fully withdraw from politics or at least stay quiet on select issues. The proposal provoked Tilak's most extensive comment on the politics of mercy. He stated that mercy would only be acceptable on 3 specific grounds: 1, legal; 2, equitable; and 3, humanitarian. And if all those prove useless, we should, in caps, not go beyond them. The legal option, Tilak explained, had already been closed by the Privy Council decision. Equity related to civil rights. More specifically, Tilak argued that trial by jury was a constitutional right, especially in cases involving state crimes. In the colony, this right was denied to Indians. Humanitarian grounds refer to the severity of the sentence. Tilak would agree to mercy if the state accepted that the sentence was too severe given the nature of his offence and factoring in his age and public position. Tilak then extolled at length why these rules were important. He argued that to accept mercy on any other conditions would be to undo his life's work. Moreover, to win freedom by abandoning his right to participate in political life would be, in his words, to, quote, live as a dead man. This was a highly important comment. Until this point, colonial mercy had performed its political work comparatively quietly. For the first time, Tilak's struggles with the state dragged the politics of colonial mercy into the open. With these lines drawn, Tilak's first petition for pardon or remission was submitted to the Secretary of State in February 1910. The petition was addressed to the King and repeated earlier arguments made to the Privy Council regarding the unlawful nature of his conviction. Tilak framed his request on the strict grounds of injustice and asked the imperial sovereign for either a full pardon or the commutation of his remaining sentence. Tilak's efforts of reaching the foot of the merciful sovereign would fail. Lord Morley withheld the petition. The following year, Tilak's attention shifted to the House of Lords. Move on. So when Tilak received news that the Secretary of State had withheld his petition, he wrote that he submits many more petitions. There was now not even, quote, the slightest chance of my early release. Nonetheless, he urged his friends to continue to press his case. As late as August 1913, just months before his term of imprisonment was complete, he summarised his long-standing position on the politics of petitioning and appealing his case. In a letter to his friend M.D. Vidvans, he stressed that, quote, we must not give up trying again and again till the last moment. Knock and it will open, says the Bible. On a purely practical level, the perpetual search for new ways to challenge the justice of the case had helped to keep Tilak's case alive. The act of submitting a petition sustained pressure on the government and maintained a public interest in his plight. There was also, however, a deeper politics at play. Tilak had transformed political technologies petitions into political technologies that enabled him to constantly repeat his argument about colonial injustice and test the outer limits of political rights available in the colony. As he refused to moderate his position on mercy, Tilak persistently asked a specific question. When colonial courts were understood as sites of illegal and despotic terror, could a colonial subject expect a merciful sovereign to intervene on the simple grounds of justice and political liberty? As his efforts were rejected, withheld, and dismissed, he seemed to have found his answer.